Judy. It's been a little while since you've joined us.
Good morning.
So I think you have some language to share with us.
Yes, I see Sorsha has already posted it. So it's under my name today. Would you like me to share my screen?
Yes, please. Thank you.
Thanks. For the record, Abby Shepherd, Office of Legislative Counsel. So the way this is drafted, yes, sorry, I'm just going. Screen.
Yes.
Okay, there you go. So I know that you saw some, oops, sorry. So jumpy. I know that you saw some language yesterday presented by my colleagues, Katie and Beth. This would be after that. So the instances of amendment that you saw, this would slot in following that. The effective dates that you see are just those relating to the tax provisions. So it's more or less exactly what would be shown in an actual amendment. It's just only the tax provisions. This, it's 9 pages of language. This is both what you have seen that Pat Titterton from JFO has been presenting as the different proposals. It also includes some other proposals that were discussed, I think, at the beginning of the session. It's been a month or so regarding the child tax credit. So there are a few sort of technical changes to both child tax credit and the EITC that are also in this language, and I'll walk you through how they all fit together. There are different effective dates for the different provisions. So starting first with the proposal to fund childcare, there are 2 different instances where personal income tax rates would be increased. First in taxable year 24, so this wouldn't be affecting any taxpayers until they file in 25. The way it's drafted is session law, and it does make several references to the tax rates and brackets parts of statute. It's drafted this way rather than going in and amending the rates, because as you'll recall, the rates are marginal. So the brackets have different levels of income that are adjusted annually for inflation. So the current statute right now, if you go and look at this section 5822, has income brackets that are adjusted every year for inflation, but are not updated in statute. So you'll see what was enacted in 2018.
And this is just like a current law situation.
Yes, absolutely.
It's not.
So this is just I'm trying to explain all of this language and why it's so technically, it looks like a lot of language when really all that the effect of this would be is increasing the rates. As you'll see here for the first bracket, what is currently subject to 3.35% would become 3.65%. So the increases are progressive as you get higher up in the marginal rates. So what's currently subject to 6.6% will become a 7.3% rate, 6.7 will become 8.3%, and 8.75 will become 9.6%. And then the language gives my office, Legislative Counsel, the authority when publishing the statute. So it won't actually be the Green Book, it'll be the White Book, because it's amending the Green Book. We only publish those once every 10 years or so. Both the income brackets and the rates will be updated in that version. So what you see online will be updated. And within this language, in this subdivision 2 at the top of the page on page 2, it does say update the taxable income brackets in statute to the most recent taxable year amounts that are available. That is not specifically to the current taxable year, depending on when we're publishing these. I wanted to leave our office the authority to use the most recent in case the inflation adjustments have come out. It's unlikely given the way that our publication schedule works. Typically this is done in October, but if the inflation adjustments were, say, in November or perhaps December, it has happened recently that our publisher has been a little bit delayed, so we might be able to have the most recent tax brackets. All of that to say, the rates will be updated and the brackets will be updated. So that's the first change. The second change is in taxable year 28. I just put them together, just hopefully that's the most logical. This section 25 would have a different effective date, of course. So taxable year 28 which means it will impact fiscal year 29. And when individuals are filing in calendar year 29 is when they would see the impact of this rate change. So you see here, unlike, because in section 25 in taxable year 24, the first rate will be 3.65. So that'll be increased an additional percentage point to 3.8%. The next bracket will be, or marginal rate will be increased from 7.3 to 7.5. 830 will be increased to 8.55, and 9.6 will be increased to 10.05. And if you prefer chart format, I know Pat's presentation yesterday has all of this laid out in charts. And then the same authority is given to Legislative Council to update the rates and the brackets as adjusted for inflation when we publish statutes.
Just to be sure that under this language, as of 2028,
Yes.
independently of what's happening with the inflation adjustment cannot or will not trump the stated rate that goes into effect.
So the rates are not inflated for adjustment, it's just the income.
Okay,
So
The
that's,
brackets keep on shifting upwards.
gotcha. All right, now I get it. Okay, thank you. So those will not be interfered with, just the income brackets.
Exactly.
Thank you.
yes, thank you for clarifying that.
Yeah.
Sorry, my scrolling is a little glitchy, sorry. So that is for the personal income tax rate changes. The other proposal is to increase the corporate income tax rates. And if you'll recall, there are two different ways of paying tax to Vermont and the corporate income tax. There is the marginal rate or marginal brackets in that rate schedule, and then there's the minimum amount. The minimum amounts were changed effective starting this taxable year. Last session, those are not changed in this proposal. The proposal here is to change the marginal rates that apply to Vermont net income. So that's income that's attributable and allocable to Vermont, and that's profits. So it's not gross receipts, it's profits that would be subject to corporate income tax. It does not change the brackets, it just changes the rates. And again, the rate increases are progressive as you move through the brackets. So the first change is from 6% to 6.5%. The second change is from 7 to 8%, and the third change on the marginal rate, the highest rate there is 8.5 to 10%. Okay. So those are the two increases to revenues. There are other changes made in this draft to the earned income tax credit and to the child tax credit. I was trying different ways to lay out the bill so that it was the most logical. I grouped it by the credits. There are a few different changes happening here, so not all of them are related to the child care funding. They are both technical proposals from the department to align the way that the credit is calculated with how other credits are calculated. There are also some changes regarding taxpayer identification numbers. So in the first section here, this is the earned income tax credit. This section would take effect for this taxable year. So it's actually retroactive to the start of 2023. And this is not related to the child care funding. So the first change is similar to language that the committee has seen for the child tax credit, where it would allow taxpayers, regardless of their taxpayer identification number, so neither a social security or something called an ITIN, which is individual taxpayer number that the IRS creates for individuals who don't have a social security number. It's just so that they can file because they have income. This would allow an individual in Vermont to claim the Vermont earned income tax credit, regardless of their identification number. So those are these changes you see on lines 6 through 10. And then again.
And just for the committee's context, I think we talked about this in the context of the child tax
Exactly.
credit already, but, and you just said that, Abby. And we can have JFOs state it again for the record, but it's, both changes are considered to be de minimis in terms of impact. So, just like context of provide credit, happy to say that again. Sorry, back to you.
Thank you. So that is the first change. The second change is there are two places in this section of statute on line 16, line 18, you'll see earned has been struck. This final clause of the current earned income tax statute is very similar to what was enacted last session for the child tax credit and for the child and dependent care credit, which passed out of this body in the miscellaneous tax bill. So the proposal initially from the department was to make all of these calculations the same for each of these three credits. And the way that this lines up, so it's multiplying, it's reducing the amount of the credit by the amount of the individual's income that they earn in Vermont versus what's earned outside of Vermont. And the change here is to remove earned income so that it's looking at the same type of income across all three credits, because the child tax credit doesn't look at whether the income is earned, it's just any income. So that's really more of a technical change. And I did just want to make clear that I might have misstated that slightly. The way that the child and dependent care credit does not currently have any phase out, but the language that this body voted out in the miscellaneous tax bill added this into the child and dependent care credit. Makes sense. And then, again, this language is in the child tax credit. So those are the technical changes. Section 27 would take effect for taxable year 23. Section 28 is, again, in the earned income tax credit statute. And this is the section that would, that is being proposed within the child care funding context. So this section would take effect in tax year 24. And it makes a couple of changes. The first is crossing out the current percentage of this credit. So this is based on the federal earned income tax credit. It's currently a 38% credit. It's 38% of the amount that the individual is granted under federal law. That 38% is crossed out and it creates a new calculation starting on line 13 in subdivision 2. So it splits how the percentage is determined, and it changes the percentage amounts based on whether the individual who's claiming the credit has one or more qualifying children. So for those who have one or more qualifying children, they get 100% of the federal credit under this language. For an individual who does not have any qualifying children, they get 55%. And something to note here, because this is taking effect in tax year 24, the language already includes, because.
Did you ever reverse that? Yeah. So we were doing 100, we were planning on doing 100% for people without children.
Oh, did I get that backwards?
You carried through.
What's really funny is that Pat had a typo in her PowerPoint. It had the same typo on, anyway.
I think it's counterintuitive.
It is, that's exactly what it
Right,
is.
because you get less when you do not have children. Okay,
Yes,
and so
yeah.
I
That was nice. And I'm sorry I didn't notice it when I read through it.
That would have been a miscommunication on my part.
sorry, well, I was listening in part yesterday, clearly not closely enough. I will swap the percentage amounts, my apologies. One thing I did want to note is that it will be 100%, and because in section 27, Vermont law will have already been changed to allow individuals who don't have social security numbers or ITINs to file it. For the EITC, you need to have a social security number, so you don't need a social security number to claim the Vermont credit. That also will expand the credit for those who do not claim qualifying children, because those children will become qualifying under this. But I will swap the percentages, send you an updated. Okay, so that is the extent of the changes to the EITC. The next two sections are amending the child tax credit statute. So the first change, and these two sections would take effect retroactively to the start of this year. And this is all language that you've seen and is not changed in this draft. So it would allow a taxpayer who is claiming a child tax credit and a qualifying child who do not have a social security number or an ITIN to claim or to be claimed for the child tax credit. And you'll see here in this final sentence is the language about phasing out the amount of the credit. And that's what's being harmonized across three different credits, the child and dependent care credit and the EITC, to line up with the child tax credit phase.
And that was a request from the administration.
Yes. The second section, I'm sorry, there are three sections here. I split it up because of the effective date. So this is, actually, I'll come back to section 30. Section 31 has already been presented to the committee. This relates to establishing a program to make advance quarterly payments of the child tax credit. This does not take effect. It actually has a contingent effective date, so it will only take effect if federal law and regulations are changed to allow state refundable tax credits to not be included when an individual is applying for benefits or other assistance programs. So this has a contingency that if or whenever those federal benefit program laws are changed, this will take effect. So the commissioner would pay in advance quarterly payments, half of the child tax credit. And then at the time of filing, the individual would sort of true up and get the remaining 50% or whatever the total amount is. They'll get that remaining percent when they actually file.
But this isn't effective until a magical time in the future.
Correct. Yes, it's, so this was done, there's a couple of different, about 10 years ago, maybe a little less than 10 years ago, a couple of similar contingent effective dates for different tax situations. One was prior to Wayfair passing that it overruled the Quill Supreme Court jurisprudence that required states to only collect from sellers if they had a physical presence. Vermont sort of foresaw that law was going to be overturned. So there was a contingent effective date of Vermont can start collecting from online remote sellers when the physical presence requirement is removed. So the effective date is sort of modeled on that contingency. There is some precedence for foreseeing that there might be a federal change kicking in a new statute. So that, going back to section 30, this is new language. Can't show you the whole thing on one page. Section 30 would add a new section into the income tax chapter. It's a subchapter that relates to credits. Both the child tax credit and the earned income tax credit are in that subchapter. This would add a new section relating to the ability of taxpayers to claim when they don't have a social security number or an ITIN. It requires the department to provide a process for those individuals to file and claim the credit, even though they're not able to claim or file federally because they lack those taxpayer identification numbers. It does have some further language that is based on statute in California to clarify that an individual does need to be able to provide documents showing their identity, as well as their income. This is fairly broad, so it does leave discretion up to the commissioner to determine how and in what form and what those documents would be that the individual would need to provide. And then it would also require the individual to notify the commissioner if that individual does get a valid social security number. So that is new language that hasn't been shown here yet. And that would take effect immediately as well. Retroactive to the start of this tax year.
Yes, it's like there's a few questions, let's go ahead, jump in.
So do I understand this correctly that once the person gets a social security number, they have to report it, of course. But then before that, they're okay applying for the EITC if they have some document that identifies them and their wages for the year. So it could be a tax return, could be a W-2 given to them by their employer.
Correct.
That would be all they need before they get the social security number.
Correct. Well, yes, that discretion is left up to the commissioner to determine what documents those would be.
Or to create a form.
Or to create a form, and the other possibility, and the department would need to speak to how feasible that is, would be through this process, they would potentially be creating a unique ID number for that individual just at the state level.
This person would fall into the percentages that everybody else would fall into, right?
Correct, based on whether they have dependents or not.
Yeah, okay.
Do other states have that?
So California and Colorado both had provisions during COVID, and I'm sorry, I'm forgetting now. I think it's Colorado's has since been repealed, but I can follow.
Was
through.
Maine?
I'm not sure. Those are the two that I've
I think
looked at, but.
like.
Yes, sorry, I'm looking at Pat because I think he maybe provided that example, but I don't want to put him on the spot. Yes, Maine, I think, has, does not require a social for certain credits.
And Craig will come in and speak to the feasibility of this as well.
As I recall, the hangup was a citizenship issue to get a social security card. And so
Oh,
there's an interim before you're in limbo.
yeah.
Pat, do you want to jump in?
Sure, so Pat Turkerton, joined the fiscal office. I just want to confirm what Abby said, Maine does allow ITINs. And they do have their own form, which is what she's just been referencing to get at what they should have received. Whatever low, you have to apply that to their percentages.
Yes, so I again would defer to the department as to how they would administer this for these taxpayers, essentially, whether they would be creating a sort of a pro forma or just using the lines from the federal tax form to calculate the Vermont credit. So moving into the effective dates, if there aren't any other questions, I have stuck asterisks here with highlighting because just again, would be following the amendment language you've already seen. So this would be in subsection B of the existing effective date language. Just didn't want to show it here to confuse anyone. This is just the tax related language. So for, I tried to do it more in order of the section numbers, but it does jump around a little bit. The increases to personal income tax rates under the corporate income tax rates, as well as the earned income tax credit split. That would take effect next January 1st. So it would be applying to tax returns filed in 25. The taxable year 28 increases to personal income tax rates would apply January 1st, 2028. So again, that would be affecting calendar year 29 filers. There is the sort of standard notwithstanding language to allow these other provisions relating to the earned income tax credit and the child tax credit, all the taxpayer identification number changes. Those would take effect retroactively to the start of this year. So when individuals file next year, they would be eligible, the expanded credit would be eligible to those taxpayers without identification numbers. And then last, the final effective date in subdivision 7 is this very lengthy language creating a contingency. So if there is any federal action that would allow a state refundable income tax credit not to be counted in benefit program calculations, that language you saw about the department providing advance quarterly payments of the child tax credit would take effect. So until then, the language that's in section 31, it will show up in sort of the appendices. There are notes in the white books, so the session law books. So there will be a note. It won't be online and it won't be showing in statute because it won't be effective law.
And we use this mechanism with something else.
Wayfair. Yes, that's how Vermont was able to start collecting. And this does delay the implementation slightly. It's not till the first day of the second quarter after any federal change is made, so that there would be time to start rolling out the advance payments.
One thing I'm thinking about is given all of the emphasis we're putting on pass-through income here, further up in the bill, if it would make sense to put S45 into here.
I think adding the salt tax in here would be great, with maybe a different number for the.
Yes, maybe changing the percentages around.
Yeah, it's currently at 90%. Back in the
So
state.
then was Connecticut 87.5?
I
Yes.
feel like Heidi's willing to go as low as 85 at some point.
Why wouldn't we just leave it as it is since we're increasing the rate of the bill?
That's a good point.
Just a thought.
Other thoughts?
Makes sense.
Let's do it.
Abby, can you shove that in wherever you put these? Thanks.
And I will
And
make,
maybe-
To be so, yeah,
I think we still have to decide on the percentages maybe, and probably have Pat help us with that a little bit, because I know that the modeling is. Is it Ted? Yes, please.
okay.
That would be great, thank you. Okay. Anything else on this language, questions, thoughts? Okay, team. I think we're gonna recess until we find Ted. And as of now, we have nothing for after lunch on the agenda. Beth is redrafting some stuff on pre-K based on people's thoughts yesterday. And Katie is redrafting some stuff based on conversations yesterday, but no one is ready to come back to us.
Does that mean like stay close to your phone?
Stay
We
close
might
to
be
your
called
phone, and
back.
if you're a person who tends to not stay close to your phone, stay close to your phone.
Not naming names.
I know that Catherine's gonna stay close to her phone.